Question is that the bill be now read a second time. As many as of the opinion say aye. Sorry? Oh, sorry. Senior Minister State.
I'd like to respond, sir.
Jump the gun.
Mr. Speaker, I thank the members who have spoken for their support of the bill, and I in particular appreciate the Intellectual Property Students Association's input through Mr. Luizeng. Their activism and their interest in legal development in their chosen area is something to be encouraged. Members have raised points for clarification in 4 main areas, and I propose to deal with them as a whole under these 4 areas. Mr. Patrick Tay asked about whether the specialized track would be effective in keeping litigation costs down, and Mr. Ng also asked a few questions about the features of the specialized track. First, Mr. Ng's suggestions and proposals in relation to how we design this track, what we take into account, we'll consider them when we prepare the relevant rules on them. The specialized track focuses on lowering costs by having simplified processes and other cost-saving features. This obviously has to deal with the appropriate types of cases, and not every case will be suitable for the specialized quick track. I will elaborate on some of the features which we are considering, although they are not part of the bill. There will be early and active case management by the court. This would ensure that cases are managed in an appropriate manner with procedures that are streamlined and cost-effective. So we sift the cases up front to ensure that they are appropriate. And to Mr. Ng's point about whether separate proceedings may have to be filed if one determines halfway through the specialized track that it is not suitable, that is unlikely to happen given the upfront proactive judicial management or rather case management of the process. We are considering a cap of 500,000 on the value of the claim for damages or on account of profits. This specialized track is appropriate for lower value cases, which of course tends to then to be less complex, and the cap on the value of the claim reflects this. We are also considering a cap on the party and party costs awarded. This would be stage-based, in other words, based on the stage of the proceedings of the litigation, with an overall cap of 50,000. This will also help to lower the business risks of litigation that members spoke about. On the 2-day cap for the length of trial, we propose to cap it, but at the same time also allow the trial judge discretion to extend this in the appropriate circumstances. So if, for example, a case is being heard and halfway through you might need another half a day, obviously the trial judge will have their discretion to do so. This will reduce the time spent and consequently the cost for the parties. The cap on 2 days, and Mr. Ng asked how that was derived, was based on the recommendations of the IP Dispute Resolution Review Committee, which I'm sure Mr. Ng knows comprise representatives from the judiciary as well, IP lawyers who handle these cases, academia, and also IP-rich companies who viewed this as appropriate for the less complex cases. So we took a sampling of these views and proposed the 2 days on that basis. Regarding the relief that the trial judge can grant, it is intended that the trial judge's power to grant interim and final relief would be the same, whether a case is on a specialized track or on a default track. In other words, the remedies that one might expect to see ought not be different. It's just that the process and the speed by which you resolve the case could be different depending on the complexity and the nature of the case. Regarding appeals, final decisions in cases on the specialized track will be appealable in the same manner as final decisions in cases on the default track. As the appeal is a separate process, the time spent on the appeal hearing is not included in the 2-day hearing cap for cases on the specialized track. Mr. Tay asked whether the cost of arbitration of IP disputes will escalate as a result of moving certain IP disputes to the High Court. That has not been our sense, and also when we look at the feedback from the committee, that is also not the sense that they get. But we'll continue to monitor this as we actually implement this process. Further, as arbitration and litigation are separate and distinct methods of resolving disputes, we do not anticipate that the amendments to consolidate litigation of most civil IP disputes in a High Court will directly impact the cost of arbitration. In other words, parties chose arbitration sometimes for different reasons for why they want to have the matter resolved in court. Mr. Tay and Mr. D'Souza asked about the expertise and resources required by the High Court pursuant to the consolidation of civil IP disputes in the High Court. As I mentioned in my speech earlier, the High Court already has a specialist bench of IP judges with greater experience and expertise in IP matters. My ministry will continue to work with the courts to ensure that there are sufficient resources to handle the caseload as may be appropriate. Next, I turn to Mr. Ng's and Mr. D'Souza's questions around the rigor of the third-party observation process, and I'll just address the queries that have been raised together. First, as far as the anonymity is concerned, I think Mr. Ng raised this point. If there is no identifier on the documents containing the third-party observation, then the identity of the observer will not be known. So in other words, you can choose to be anonymous or not be anonymous as you wish as the third party. Second, I think Mr. Ng also asked about whether the records will be available. The records of the patent search and the examination history are available to the public on the patent's open dossier service. This will include the contents of the third-party observations filed before the deadline, as well as the applicant's response to the examiner's written opinion incorporating any observation where there is one. So all of that will be made available on the patent's open dossier service. Third, the new Section 32(1) of the Patents Act, inserted by Clause 10 of the bill, provides that third parties may make observations on the question whether the invention in the patent application is a patentable one. I touched on this in my earlier speech, but the statutory requirements for an invention to be patentable can be found in Section 13 of the Patents Act. Hence, for example, a third party could make an observation that the invention is not new because of an earlier publication. Fourth, there will be no fee to submit third-party observations. Finally, when a third-party observation is made, the patent examiner would have to take some additional time to consider it. However, the patent application period will not be unduly lengthened, as Rule 46(8)(a) of the patent rules requires the examiner to issue the examination report within a fixed time period, regardless of whether a third-party observation is made or not. So that helps to address members' concerns as to whether there will be an overall prolongation of the process because of the observations. A healthy patent regime encourages innovation and protects only deserving inventions. Third-party observations which are meritorious contribute to this and will be worth the time taken to consider it, so that overall we develop a more robust and more trustworthy IP system and regime. Mr. D'Souza also asked a few questions about the post-grant patent re-examination process. First, about the safeguards. When a re-examination request is made, the specification of the patent will first be re-examined by the patent examiner. The examiner will ask the patent proprietor to respond only if there are possible grounds for the patent to be revoked. This avoids placing an unnecessary burden on the patent proprietor. Second, Mr. D'Souza asked why there is no bar against filing a re-examination request when there is an ongoing arbitration proceeding in which the validity of the patent may be in issue. This is because arbitration proceedings cannot affect the status of the patents on the patent register. In contrast, proceedings before the court or IPOS in which the validity of the patent may be an issue could lead to the patent being revoked. In other words, the patent itself being revoked, as opposed to the rights as between two parties. Hence, the new Section 38(a)(5) is necessary to prevent concurrent proceedings in which the status of the patent on the patents register could be affected. This is not applicable in the context of an arbitration. Mr. Ng and Mr. D'Souza asked some questions about the arbitrability of the IP disputes. Let me address those. First, as to whether IP rights found in employment contracts are arbitrable. The bill is intended to clarify that a wide range of IP disputes are arbitrable. In employment contracts, it is common to find clauses about the ownership of IP rights that arise in the employee's course of work, and I think that's what Mr. Ng seems to be referring to in his speech. If there are disputes subsequently about the ownership of these rights, so the ownership of these IP rights, then these disputes are arbitrable. Ownership disputes are within the scope of IPR dispute, which will be defined in the new Section 52(a)(3) of the Arbitration Act and 26(a)(4) of the International Arbitration Act, inserted by clauses 2 and 8 of the bill respectively. I just want to add that what's arbitrable doesn't necessarily mean that it will be the subject of an arbitration, because it's still defined by the scope of the arbitration agreement. Second, he asked whether the arbitral awards for patent validity disputes can serve as a basis to amend the patent on the register. In my earlier speech, I had explained that the arbitral awards only affect the parties to the arbitration agreement and will not affect the status of IP rights on the register. This is because we take the view that decisions that affect the status of IP rights on the registers should only be made by the courts or the relevant registrars from the jurisdictions that issued those IP rights, since these are decisions that affect the world at large concerning the registration, and not just the parties to the arbitration proceedings. This is true not only of patents, but of other forms of registrable IP rights, such as trademarks and also registered designs. Mr. D'Souza asked how an arbitration award involving intellectual property rights affects a third-party holder of security interest. Such an award does not affect any existing right or liability between a third-party holder of a security interest and a party to the arbitral proceedings, whether arising in contract or arising by operation of law. And this is clarified in the new 52 Big C 3 of the Arbitration Act and 26 Big C 3 of the International Arbitration Act. I turn now to the other queries that have been raised. Mr. Tay asked whether more could be done to help SMEs and startups navigate the IP registration and dispute resolution regime. I thank Mr. Tay for looking out for the interests of the labour movement. In general, and I think Mr. D'Souza also asked some questions about training and whether the users of the system will have knowledge and know-how. The IPOS website provides useful information on the IP registration system. If anyone requires further assistance, he can always call IPOS for help with queries or make an appointment to see an officer at IPOS. For assistance with IP-related disputes, there are legal clinics at IPOS where there's a panel of lawyers available to provide preliminary advice on, for example, infringement or opposition matters. To assist those seeking such advice, they can obtain reimbursement from IPOS for the consultation fee for the first session. IPOS also runs complimentary IP business clinics that allow participants to speak with private business consultants on IP strategies, franchising and licensing, audits and valuation, amongst other issues related to or arising from IP rights. Mr. D'Souza asked about the efforts to strengthen our legal industry so that it can benefit from these reforms. My ministry and the relevant agencies will be engaging stakeholders in the IP and legal sector to explain how these changes can benefit them, how they will operate in this new landscape, and how they could make use of it. This will not just extend to practitioners, but also businesses in the business environment, big and small companies who use the system and whom our IP regime is really intended to support. In other words, the stakeholders who benefit from the IP regime. I think Mr. D'Souza also raised a point about cost, and I think the point that Mr. D'Souza made was why it is that the bill which provides for indemnity costs under certain conditions in Clause 6, but only valid for the geographical indications. Similar amendments will be made, as similar amendments to those, I think you refer to Clause 6B of the Geographical Indications Act. They will also be made in this bill to Clause 28 of the Registered Designs Act and Clause 34 of the Trademarks Act to bring it on to the same footing as what Mr. D'Souza refers to, and that can be found at Clauses 28 and 34 respectively for the Registered Designs and the Trademarks Act. Sir, in conclusion, the reforms introduced will enable IP right owners to resolve their IP disputes efficiently in court and at IPOS, whether they are individuals, SMEs or large corporations. This will give IP right owners greater assurance of the enforceability of their IP rights and also increase the overall quality of granted patents in Singapore. These reforms are part of our continuing efforts to improve our IP regime to support our innovative and creative industries. I wish to thank the members who have spoken and who have supported the bill. Mr. Speaker, I beg to move.
Let's try again. The question is that the bill be now read a second time. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
The Intellectual Property Dispute Resolution Bill.
Committee stage what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 45 stand part of the bill. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Law.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
The Intellectual Property Dispute Resolution Bill. Item 2, the Fire Safety Amendment Bill, second reading.
Order. I propose to take a break now. I suspend the sitting and will take the chair at 4:20 p.m. Order. Order.